Hands on the hood. Anything you don't need that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
That's not a pat down. That is pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video comes to us from the YouTube channel Duck to Police. It depicts a traffic stop in Montgomery County, Texas by Officer Norton of the local constable's office there. Now, Abaya Israel did this case on We the People as well as a couple other channels, but these folks reached out to me specifically and asked me to cover it. And it does present a bunch of interesting things that we can talk about along the way, so I thought I would give my take on it and see where we land. Now, I have edited the video for the purposes of our discussion, but you should head over to their channel and give them credit for sharing it. Let's get into it.
You gonna roll down the window? Why not? Roll down the window.
Yes, may I help you?
Officer Norton, Montgomery County Constable's Precinct 5. The reason I pulled you over is your license plate is obscured. I cannot see your license plate.
You're full of crap anyways because it's got my bicycle things on it.
It still can't be covered.
Yes, it's not covered. It is, but that
It's obscured.
legal.
No, it's not. I cannot see your license plate. I cannot see your license plate.
I'm sorry.
Okay, so it's obscured. Do you have your license on you?
Yes, I do.
Okay.
However, it's not obscured.
Okay, it is obscured.
You can call Officer Simpson, Sergeant Simpson, and ask him. It is not obscured.
So me not being able to see your back license plate, don't roll up your window on me.
Oh, watch me.
Okay.
It was an accident to begin with, so don't threaten me.
I didn't threaten you. I said
Yes,
don't roll.
you did. Don't roll up your window on me. It was an accident to begin with.
Okay,
It's wrong.
that's all I said was don't roll your window up on me. Where's your license?
It's not obscured.
Okay. We can agree to disagree. Where are you coming from today?
None of your business.
Okay, cool. Any weapons in the vehicle?
None of your business.
It is my business, actually.
No, I don't have to answer any more questions.
Yeah, you do. Are there any weapons in the vehicle?
Here you go.
Are there any weapons in the vehicle?
No.
Okay. Any illegal narcotics?
I'm not answering any more questions.
Okay. Cool. Go ahead and hop out of the vehicle for me.
Excuse me?
Hop out of the vehicle.
Excuse me?
Go ahead and hop out of the vehicle.
Say that again?
Go ahead and hop out of the vehicle.
No.
Get out of the
I'm not
vehicle?
getting out of the vehicle.
Yeah, you are.
Oh, no, I am not.
Yes, you are.
No, I'm not.
Yes, you are.
No, I'm not.
8520. Can you send me another unit? I have a occupant that's refusing to get out of the vehicle.
I'm not getting out.
Yes, you are.
I do not have to answer any questions, and I am not getting out.
It's a lawful order.
No, it's not a lawful order.
Yes, it is. It is a lawful order, me telling you to get out of the vehicle.
I am not getting out of my
You can open up the channel. You can get out of the vehicle, or you can go for interfering. Okay, well, we'll sit here all day until... Okay. We'll sit here all day. All I asked was for you to get out of the vehicle.
I am not getting out of my vehicle.
I don't know what's in this vehicle. You're not telling me if there are weapons. I asked you if there are weapons. You said, I don't have to tell you. You said, I don't have to tell you. So for all I know is you have a firearm.
There is no vehicle. There's no weapons in my vehicle.
You said, I don't have to tell you.
Exactly. But I also told you there was no vehicles in my... There's no weapons in my vehicle.
Okay, cool. Well,
So I do not have to get out of my vehicle.
yeah, you do. It's a lawful order.
No, it's not.
Okay, we can agree to disagree.
I'm not doing anything wrong. There is no reason for me to get out of my vehicle, and I gave you my driver's license.
Okay, but I'm asking you to get out of the vehicle, and you're still refusing.
Getting out of my vehicle.
Okay, well, we can either pull you out.
Call Sergeant Simpson.
I don't need to call Sergeant Simpson.
There is no reason for me to get out of my vehicle. I have not done anything wrong.
So me asking you is a lawful order.
No, it is not.
Yes, it is.
It is not.
It definitely is a lawful order.
My vehicle.
Okay.
It's not a lawful order because there is no reason for it.
Okay, she already locked it.
Okay, so the first thing you probably notice is that we have a ponytail tyrant here. Every statement that she makes is dripping with sarcasm and snark and contempt for the fact that this lady didn't immediately sort of bend the knee and kiss the ring as soon as she rolled up on the traffic stop. Now, ordinarily, because of the way this kind of played out, Pennsylvania versus Mims would apply to this situation, but there's a little something that's going to be added here when she furthers along in the traffic stop that might bring MIMS into question as far as the lawfulness of the exit order. Generally speaking, she doesn't really know, based on the lady's response, whether they're weapons of the car. You could make the argument, and the courts would probably allow it, that she was getting her out for a precaution for officer safety. But an important thing just happened here. Had the officer asked the questions about the weapons and then gotten the initial response and then had the driver get out of the car, that would be a situation where the courts would say, look, she asked about weapons, the driver was not willing to answer questions, and so the officer doesn't know. She doesn't know whether the car has weapons or not. It's reasonable for her to ask her out of the vehicle because of the fact that she wasn't sure. And she's the lone officer on the scene and blah, blah, blah. I'm not saying I agree with it again. That's just probably what would happen. But this is a perfect example of how ego is the root of every problem in policing. Because had the officer just gotten her out, she probably would have been fine legally speaking. But what did she do? She kept asking, and she kept getting more shitty with every sentence she spoke. And when she asked for the second time, the lady said no, she didn't have any weapons. Well, now she has that information, and she has a choice to make. Whether she's going to believe that the lady has weapons or whether she's going to believe that the lady doesn't have weapons. And her decision as it relates to that will be based on her ego-driven approach to this traffic stop. Now, again, the court would probably still let her get by with a MIMS exit order here because she is reasonably uncertain. She doesn't know whether the lady was bluffing or whether she was giving her a hard time, whatever. But that inability to control her ego and that snark that will be obvious to everyone will give a defense lawyer an absolute field day with her as it relates to her credibility, because he's going to be able to say, well, this really isn't about officer safety. This is about officer domination. You wanted to punish her and intimidate her because of the fact that she didn't want to roll her window down or she was giving you a hard time, and because of the fact that she knew what apparently you didn't know about the law, which we're going to learn in a little bit, which is that her license plate wasn't actually legally obstructed. And again, it would be obvious to anyone watching that she told her to get out as a way to intimidate her, not because of officer safety. She's chosen to listen to the "I don't have to tell you" statement instead of the statement where she declared she didn't have any weapons. And again, that was a choice based on her emotions. It wasn't a choice based on the sort of logical landscape of the totality of the circumstance here. So she's choosing to escalate and keep the temperature high for really no reason. And because this officer has zero skills in de-escalation, we're now having a standoff and we have additional units en route because this girl doesn't know how to talk to people. So now she's already threatened to arrest her if she doesn't get out. So her claim, should she decide to file a 1983 suit, would still be valid if she gets out under the threat of arrest, just the same as if she'd actually been arrested. And then ultimately she does, which we'll see. Let's continue.
That's all right. We got a sergeant on the line right now. See? He's en route. So you can sit here or you can comply with our orders.
There is no vehicle. There is no reason for me to get out of my vehicle.
I don't know what's in this vehicle. You were hesitant on me asking if there were any weapons in the vehicle, and you said no, I don't have to tell you. So
No weapons in my vehicle. And do not shine your flashlight in my eyes. I'm deaf.
You're deaf?
well, that has nothing to do with a flashlight in your eyes.
Okay.
No, it doesn't.
But I can't see you in order to hear you.
You're not even looking at us.
I can hear you because you're loud enough.
You can hear us,
Not,
but you're not looking at us.
no, I can't. Not now. I can't.
Okay. Anyways, I'm gonna run her.
It's a very common thing across the country as well. It's not even just our community here.
So this lady tells the officer, don't shine your flashlight in my eyes because I'm deaf. And of course what she got was a smart-ass response from the police officer, because the officer doesn't have enough common sense to understand that deaf people need to read lips and to actually be able to see the people that they're communicating with. Because this is going to blow your mind, but they can't hear them. So now she's crossed over into mistreating a person with a verifiable disability just to assert her dominance and authority. And of course, you'll notice that the officer who could actually communicate without being a hothead was able to coax the driver out of the vehicle without incident. Now, pay close attention to this next part, because Officer Norton here is going to demonstrate that she really does not have much of a grasp on anything related to constitutional procedure when she attempts to do a pat-down. Let's watch.
Hands on the hood. Anything on me that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
that's not a pat down. That is to pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
Is that I'm allowed to?
No, you're not.
Okay. Where are you coming from today? Not gonna answer? Okay. Anything in the car that you're not supposed to have?
No.
Okay. Have you ever been in trouble with the law before?
No.
No.
Okay, so the lady checks her on this pat down and tells her, this is not a pat down when you go under my bra. This is a search. It's not a pat down. And this officer, of course, argues with her that she's permitted to do it. And the driver here is 100% correct. A pat down is exactly what it sounds like. You pat down the outer clothing to feel for weapons. You are not permitted under the auspices of a pat down to manipulate anything under the clothing. And of course that would include sliding your fingers under the bra strap in order to feel what's under there. That is a search. It's not a pat down. This is 100% illegal based on the ruling in Terry versus Ohio if she had what Terry required for a pat down to begin with. But I'll go one step further. Even a pat down would not be justified here because outside of a completely unreasonable refusal to accept the driver's answer to the question about weapons, this officer has no information to form what Terry requires for a pat down. Remember, Terry requires reasonable articulable suspicion of criminal activity for the stop. And then for a pat down, the officer needs information that would form the basis of a reasonable belief that the person they're dealing with is armed and dangerous. There's literally nothing here to suggest that. A pat down, even if done correctly, would not be justified here in my opinion. But again, this is actually a search, not a pat down. So completely unjustified. Let's continue. Okay, so notice how the officer asked questions, asked for consent to search, and then when the driver refused, she immediately went back to her vehicle and called to see if they have a canine officer available. This is a violation of Rodriguez versus United States, which was a United States Supreme Court decision from 2015. You may be familiar with it, but this case was about extending traffic stops beyond a reasonable amount of time in order to conduct the mission of the traffic stop itself. So in Rodriguez, the facts are actually pretty simple. An officer stopped Rodriguez for passing on the shoulder of the road. He did all the regular stuff, attended to the traffic stop, and then issued Rodriguez a warning ticket. But he decided he wanted to search Rodriguez's car because Rodriguez was kind of giving him some nervous responses in answering the officer's questions. So after he gives him the warning ticket, he asks Rodriguez for permission to search. Rodriguez says no. And so the officer makes the decision at that point that he's going to hold Rodriguez after the traffic stop ended and after he had actually issued the warning in order for a canine to be able to get there and sweep the vehicle for narcotics. So they actually do hold him. The canine officer arrives, sweeps the vehicle, and the canine hit on the car. The officer searched and found a bunch of dope, and Rodriguez was charged and convicted at trial. But in the appellate process, it made its way all the way to the United States Supreme Court, and the court looked at it and it said, look, the mission of the traffic stop is related in scope to the reason that the person was stopped. So in Rodriguez's cases, if you were to stop him for an improper lane change or passing on the side of the road, whatever it is, your job is to focus on that. The second that you write the ticket, the stop's over. In order to justify holding Rodriguez for a canine, you would have to have separate reasonable articulable suspicion of some crime related to the need for a canine sweep. And the officers didn't have that. The officers in holding him relied on a case called Illinois versus Caballas, which was another canine case where the Supreme Court basically said that sweeping a canine around the car was not a search. And the police, of course, always take as much liberty as they possibly can with these opinions. So they took the position that they were permitted under Caballas to hold this driver so they could not search the outside of the vehicle and give a canine an opportunity to sweep it. But the court was like, no, you're missing the point. The point is, you can't hold somebody for an unreasonable amount of time to do something based on a hunch. The second you're done with the traffic stop, if you don't have a reasonable articulable suspicion for a new investigation, you're back in Terry land and you need reasonable articulable suspicion in order to do a new detention. And so that's why the court said no, holding them longer than it takes to complete the mission of the traffic stop is a violation of the Fourth Amendment because it's an unreasonable amount of time. In Caballas, the officer was dealing with the traffic stop, writing the ticket, doing all the stuff, and a different officer ran a canine around the car. In Rodriguez, the stop was over, and the cops held Rodriguez specifically for a canine, and that is what differentiated those two cases. So again, in order to extend the stop, or even deviate from the original mission of the stop, and start investigating something else, The police have to have separate reasonable articulable suspicion of a different crime. Let's continue.
So there's nothing inside the vehicle that you're not supposed to have?
No.
Okay. Do you mind if I search the vehicle?
Yes, I do.
Okay. Okay. Stay right there. Do we have any canines? Bruh, no. Do you have any canines on? Your home? 8520. Can you make note that the occupant got out of the vehicle? And do we have any canine narcotics available?
Any available narcotics canine to assist you, please?
Huh?
Good.
Yeah.
It's too many of us. Let me get out
Yeah.
of here.
I'm gonna wonder if that's enough for me to. Because technically she was interfering.
Oh, yeah. I've done it.
I'm gonna call the DA. Did you call the DA before you? Yeah.
Yeah, well, my guy had physically had to remove him out of the car. Because
Yeah, but how many times did we ask her? You know,
oh, yeah,
it took
absolutely. No,
it took 4
I
units.
only asked mine 3 times before I took it.
All right, I'm gonna call the DA. Hello, it's Officer Norton with Montgomery County Constables Precinct 5. I got a question for you. So out on a traffic stop for obscured license plate. She has like bikes covering her license plate. I can't see the license plate. When I told her that I wasn't able to see the rear license plate, she argued with me and says that it's not obscured, this, and this. I asked her multiple times to get out of the vehicle, because when I asked her, sorry, hold on. When I asked if there were any weapons in the vehicle, she said that she didn't have to tell me. And I said, well, it's for officer safety, this, and this. And finally, after asking her multiple times, she said, no, there's no weapons in the vehicle. I then asked her, okay, well, do you mind stepping out? That way I know, you know, for my safety, your safety, everything's okay. She then rolled up the passenger window, said it was an accident. And then she refused to get out of the vehicle when I asked her multiple times. It took 4 other officers to ask her verbally. We didn't have to physically remove her. But she finally got out of the vehicle. And then as I'm patting her down, seeing if she stuffed anything anywhere in her bra, she said that I was not doing a pat down, that I was illegally searching her. So I was going to see if that's enough for interference.
Give me a second, I'm going to look at something.
Okay.
So on top of having no people skills whatsoever, we now know that Officer Norton is also willing to lie to the district attorney in order to justify her actions. Now that should tell you a couple of things. First and foremost, it tells you that she doesn't have any integrity, which you probably could have figured out by the way she's treating this lady. But secondly, it should tell you that she understands that the way she was behaving is not appropriate. Because in order for her to seem reasonable to someone in authority over her, she had to change the nature of her actions. Which means, again, that she knows that she was wrong. So she never mentioned officer safety to the driver. She never said anything about, I need to make sure we're both safe, or showed any emotion other than being an entitled, ego-driven little brat and asserting her authority over this lady. And had she taken a different approach, we probably wouldn't be here. But her sort of disguising this and packaging it up as if she was the reasonable one and this lady was the unreasonable one is insane. And it's a complete lie that anyone could be able to discover by watching the body cam footage. But the worst part of this video is yet to come.
Okay, here's where you're at. I'm with you. Technically, yes, you have the violation if you want to file it. However, there are some problems that will make you look terribly bad if you have to defend this case in court.
Okay, hold on. I have to stop this here because what you just heard from the DA is absolutely appalling. He said to her, technically, you could file a violation if you wanted to, but there's a part of the statute that's going to make you look really, really bad if you try to defend it in court. What? That means it's not legal. My head is literally about to explode. For one, he's the one who has to defend it in court, not her. She's a witness for the state. It's the state's case. And if it will make her look terrible in the process of trying to defend it, that means it lacks probable cause and it's not reasonable. And it's actually prosecutorial misconduct to suggest to a police officer that they can move forward on a case when you know from the beginning that it lacks probable cause. So let's hear the rest of whatever nonsense he's going to say because he's already lost me as it relates to his ability to do his job properly.
Okay.
The first one is the statute that I wanted to look at is that bicycles and motorcycle racks attached to a vehicle in normal and customary manner cannot be used as a basis for obstructing a license plate. It's actually spelled out. It's actually spelled out in the statute.
Okay. Even with the bicycles on it.
I'll read it to you. Subsection A7, which is the obscured license plate, may not be construed to apply to a bicycle or motorcycle rack that is attached to a vehicle in a normal or customary manner. Now, that's problem number one. Problem number two, it sounds like she has a valid point about the search in saying that you patting her bra is not a pat down, it's a search. So the long and the short of it is, I would not do it, but if y'all really want to bite off that fight, yes, we'll file it.
No, I mean, I'm going to go with obviously what you say, because I'm calling you to get your opinion on it.
Yeah, I mean, that's where I'm at. You could easily make out the case for interference with public duties for her refusing to come out of the vehicle for an extended period and requiring a number of officers to get involved. However, a defense attorney, in my opinion, is going to eat you alive with the other two issues at a trial on that case. So I'll go whichever way y'all want to go, and I'm certainly happy if you want to talk to your sergeant about it and make a decision that way.
No. Like I said, I called you to get your kind of approval on the stuff that we got
my
out here.
take is, legally you're right. Morally, I wouldn't take that fight if I were you.
Yeah. Okay. I was under the impression that if we weren't able to see a plate in the back at all, then it was obscured.
Well, I read you the exact language, and so you can see how you think it applies to your exact facts, because you're looking at your situation live. I'm not.
Yeah, no, I got you. Yeah, I mean, I physically can't see the plate, so like I legit had to go under the bikes as I'm pulling over the vehicle to see the plate. Like there's 3 bikes.
Yeah.
So
I'm giving you my pieces, so yeah, whichever way you want to go is fine with me.
Okay. All right. Thank you so much.
Thanks. Yeah.
All right. Bye. That's there. You can disregard.
Were you wanting to speak with the sergeant, or?
You have any questions?
Nothing.
All right. Well, the sergeant's right here if you want to speak to him. If not, you're more than welcome to go on about your day.
Thank you.
Do you have any questions for me, for him? No? Okay.
Okay, so he wins back a couple points here because he does actually have the courage to educate her on the fact that there's an exemption under the law for bicycle racks. He even tells her that the driver's correct about it being a search and not a pat-down. But the DA offers to argue the case even though he knows that there's an exception under the law. He says that he'll go ahead and argue for it if the officer wants to file it anyway. And that statement it really just is unbelievable. I don't understand it. Now, I will say that I think the courts would let the police officer get by with the initial stop. And I say that because the statute leaves it ambiguous as to, it says that this law can't be construed to make it essentially illegal for a bicycle rack normally mounted to obscure a license plate. And they don't say anything about having the bikes actually in the rack. But I think the natural, logical inference to that is, why would people put racks on their vehicle if they weren't going to load them? There was a completely separate section on exceptions that included like trailer hitches and wheelchair mounts and bicycle racks and all of those things. And it seems to me like what was happening was police officers were stopping people with stuff on the back of their vehicle and writing them tickets for this. And the legislature decided to include this section to try to keep that from happening anymore. So I think it's reasonable to say, well, look, if you couldn't load it, why would they make an exception for it? Clearly, people don't just put racks on their vehicles and then not put anything in them. That's kind of what they're for. But I still think the court would allow her to get by with this as a good faith exception and say that a reasonable officer in the same situation would think that it's possible that there could be an obstructed license plate here. I don't agree with it. I'm just telling you what I think the court would do. And that leads me into my closing argument. There are a lot of things wrong in this case, but the real story is this completely inept district attorney. The job of a district attorney is to be a gatekeeper to the criminal justice system. What he should have said is, you absolutely do not have probable cause for this traffic offense. So keep that in mind, because anything you do in the way of making demands that you're going to be considering lawful orders, threatening arrest if they don't comply, using force, or anything else, you need to realize that all of that stuff, if you have no probable cause for the original stop, exposes you to liability under a 1983 claim. I'm not telling you what to do, but I want you to understand that I have ethical rules that I have to follow as a prosecutor. And one of them is that I can't prosecute a case that I know lacks probable cause. So should you choose to file this case, I can't tell you not to file it, but it will be dismissed based on a lack of probable cause. And that dismissal will be powerful should these people decide to sue, because it will be a dismissal based on probable cause and it would strengthen a civil suit against you. In fact, why don't you ask your superiors for a copy of your body cam, and let's sit down in the next couple of weeks and I'll walk you through how some of this works so that you'll know moving forward. That's what should have been said to her. That's what DAs are supposed to do. Instead, they act like they're union reps for the police departments and that their job is to defend them or advocate for them. A prosecutor's job is to advocate for justice of the citizenry, and justice of the citizenry starts with an adherence to constitutional principles. They pretend they don't see these issues, and then they wait until cops royally screw up and prosecute them to save face with the public when they could just get in front of this when they see them. They see this stuff every single day, I'm telling you, because I know, because I've done it. They are in the very best position to fix this stuff, and yet they don't. Why? They have the law degrees, they understand the law, they're in a position of authority over the police in the courtroom. They have immunity on prosecutorial discretion. They have access to the department leadership to suggest training. They have the ability to bar officers from testifying by Brady listing them. Prosecutors have the greatest opportunity to change this stuff out of anyone in the criminal justice system, and they don't do it. If there is ever going to be progress on this stuff, it will have to start with them. So by my count, this officer lacked PC for the original stop, even though the court would probably let her get by with it because they make excuses for officers at every corner. The MIM's exit order was unlawful because she didn't have a legal stop, but again, there's a decent chance the court would give her a good faith exception because she was making a mistake of law based on good faith, and the fact that she reacted to the DA giving her that information as if she didn't really know it and she was genuinely mistaken, and the fact that she gave the lady's driver's license and let her go right after that shows that she probably genuinely believed there was a violation there, even though she was wrong. Again, they give officers an excuse for everything, so I don't see a court coming down on her over that. But she certainly violated Terry versus Ohio by ordering her to endure a pat down. Then she unlawfully searched her instead of patting her down. Then she violated Rodriguez by not attending to the traffic stop and writing the ticket and calling for a canine when she refused consent to search, all while holding her there while she was trying to decide what to do and still not attending to the traffic stop itself, only to find out that she was wrong and ultimately let the driver go. So to the driver, I'm truly sorry that cops suck. I'm sorry that you were mistreated and made to feel ostracized because of your disability, or silly for bringing that up as an issue because you couldn't see through the flashlight. I think that's really in poor taste, and her department should be ashamed of her. I sincerely hope that you seek counsel for a lawsuit. I hope somebody takes your case, and at a minimum, I hope you file formal complaints on both the officer and the prosecutor. Anyway, that's all for this one. Thanks for checking it out. Please remember to like and subscribe and leave a comment on the video. Please check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.